You're listening to the Quint's podcast.
After months of political upheaval and 11 days of hearing, a three-judge bench in the Karnataka High Court upheld restrictions on Muslim women wearing a hijab in educational institutions. The bench held that the right to wear a hijab is not constitutionally protected. In its verdict, the bench, comprising of Chief Justice Ritu Awasthi and Justices Krishna S. Dixit and J.M. Khazi, stated in its verdict that, quote-unquote, "We are of the considered opinion that wearing of hijab by Muslim women does not form a part of essential religious practice in Islamic faith. The prescription of school uniform is only a reasonable restriction that is constitutionally permissible, which the students cannot object to." End quote. The court also held that the Karnataka government's 5th February order, which essentially banned the wearing of hijab in educational institutions, is sound, and that there was no case made out for its invalidation. Commenting on the High Court order, Karnataka Chief Minister Bommai asked everyone to maintain quote-unquote peace and order and allow the students to attend classes, adding that education was more important than anything else. So in today's episode, we break down the reasoning behind the Karnataka High Court's judgment and why it may be problematic. Joining me today to discuss this is Vakasha Sasdev, the Quint's legal editor. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you, and I'm your host, Himmat. Okay, so Vakasha, before we dive into the verdict, can we circle back a little to the beginning of these hearings? What were the key arguments made by the petitioners' lawyers?
So, these cases were filed by a number of the Muslim girls who were being denied entry, including those who were the very first ones, right? The ones in Udupi who were denied entry.
Yeah.
They filed these petitions. There were two sort of basic grounds at the time they were thinking of filing on, and the key ground, which I think was picked up because of a previous Kerala High Court decision, was that the wearing of a hijab is an essential religious practice in Islam. And the idea behind this was that you say, look, under Article 25 of the Constitution, you have a right to, practice and profess your faith of your choice. Now, the thing is that article, so Article 25(1), where that's specified, it does say that this is subject to public order, morality, which is to be interpreted as constitutional morality, and health. Yeah. So there are restrictions which can be imposed, and this is a slightly, the breadth of restrictions is a bit broader than something than, say, within your right to freedom of expression, your right to freedom of speech. So over the years, the Supreme Court had built up this concept that, if something is an essential religious practice, then, your protection under Article 25 is, it's wrong to say this, but is stronger, because the scrutiny which will then be applied to any restriction will be much higher. So if the government is going to come and say, we want to stop you from doing XYZ things, if those XYZ things include an essential religious practice, then the courts may be likely, are likely to step in, because then they'll really examine, is this really necessary? Is this meeting, the requirements for the restrictions, under public order, morality, or health or not? But if it's not an essential religious practice, if it's, just an ancillary practice, which is not a big deal for your religion, then, given the kind of things which the state was supposed to do, it's supposed to be looking to improve people's lives, try and, cause all this progress in Indian society and all of that. It's supposed to have the power to potentially restrict certain aspects of religious life. Yeah. So that's why these girls were thinking, obviously, let's try. We need to kind of prove this. Now, the thing was that I think what was tempting was that in the Kerala High Court had in 2016 passed an order where it said, we consider the wearing of a hijab for Muslim girls to be an essential religious practice. Because that order was passed, I think there was this temptation on the part to say, let's focus on that, because it's something which a court has already held. So let's go with it, right? There was a Madras High Court judgment which actually rejected a request by some Muslim girls, but it actually, in the course of its argument, seemed to indicate, but the wearing of hijabs is essential when you're in a co-ed space, right? Where you're with men in the area. If it's only with women, then it's not. But if it's, with men around, it can be. So what you had was, I think, this idea that, there are precedents from the past which say that it is an essential religious practice. So let's just go with that. Rather than giving more thought, and, so you see then a very perfunctory argument made that, it's also protected under the right to freedom of speech and expression, right? What you wear, it's protected under your right to privacy. And there was then an even more perfunctory argument about how it's freedom of conscience as well. And this whole thing, the way this whole hijab, this whole ban is structured, even though it's facially neutral, saying that it applies to any religious attire, it's kind of targeting Muslim girls, right? So so there was a whole argument we made about indirect discrimination, and all of these other arguments were kind of done in a bit of a slipshod manner. So essentially, what seems to have happened is that there were all these other arguments to be made, and they were perfunctorily made, but they weren't done in a lot of detail. A lot of the focus ended up being on the essential religious practice. And then on the other side, you have the Karnataka government. They come up and make their arguments about why this isn't an essential religious practice. And they focused again. Their focus also was to a large extent on that, because that was what the petitioners did. And they did have some very brief arguments to kind of address some of the other things, like freedom of conscience, on privacy and freedom of speech as well. But again, like, these things got almost shortchanged by the end, because it was a very minimal kind of thing. The whole focus essentially ended up being, during the arguments to a large extent, was on whether or not the wearing of hijabs is an essential religious practice.
Let's jump straight into the verdict as well, which came out today, which ran about 129 pages, but essentially asked four fundamental questions, which led to the bench upholding the restriction on Muslim women wearing a hijab in educational institutions and concluding that the right to wear a hijab is not constitutionally protected. Now, these questions basically determine what constitutes as an essential religious practice. So, can you take us through these questions and how the court answered them as well?
So the court's order can be broken down into three main sections. The first section, which deals with that big argument from both sides, was on whether or not it's an essential religious practice. As you said, they went into this fourfold test. Now, that was something which was laid down in the Sabrimala case. So in the Sabrimala case back then, the court had, they looked at what the Supreme Court over the years had been using for the test for what is an essential religious practice, and they culled out a sort of 4-stage test. The main issue which you have to look at here basically is, okay, if you take this away from the religion, does that have a fundamental effect on the religion, right? Does your religion have a massive change made to it if you take this particular practice away from it? The other key aspect of the test, of the 4-stage test, is what are the consequences for a person who believes the faith who no longer has to, who doesn't follow this practice? Do they get excommunicated? Are they supposed to suffer whatever, are they considered a sinner? These are the kind of things so what are the consequences really which exist? So that was the test. That was that was one issue they looked into. The second issue they looked into was, okay, looking at this, since there's an argument here that, okay, this is a right to freedom of expression and right to your right to privacy, to wear clothes which you want. Okay, sure, there may be fundamental rights, but there are reasonable restrictions under the Constitution, right? So does having these sort of uniform prescriptions in schools, can that amount to a reasonable restriction? Now, this is in the context of schools, it should be noted, not outside of it as well. The ERP thing applies across the board, but the question of reasonable restrictions is in the context of schools. And the third thing which they then looked into was whether the Karnataka government's order, which was kind of dealing with all of this back on 5th February, was that legal or not? Now, in the grand scheme of things, that's almost a lesser thing by the end, because the other two issues really are the big ones. Because the court came out very clearly, and when the judges came and read out their order at 10:30 in the morning, it was, we are of the considered opinion that wearing of hijabs is not an essential religious practice in the Islamic faith. So, like, that's a big thing, right? And they've kind of gone against what some of these other high court decisions had said in the past in saying this. They then said, in terms of the question of reasonable restrictions, there also they said, you know what, when a school wants to impose a uniform, this is a reasonable restriction. You can't say, oh, my religion says I can't wear that particular item of clothing, or I have to wear something else with it. If you're violating the uniform, they have, that's not an unreasonable thing for the school to do. So those are the two key things which I think we should focus on here, because it's an interesting thing, because the court's reasoning on the first, and the ERP issue, on the essential religious practices issue, is not necessarily problematic. It's a bit of a weird thing to say that we're going to now apply this test so strictly for something where you're not causing harm to anyone else. Because now Sabrimala, when they applied that test, right, they were looking at a thing where people were being excluded from something, right? And therefore they applied this very strict kind of test on, okay, is it impacting the religion, what is going to happen, blah, that whole sort of thing. Whereas this is a slightly different thing, right? Where when you're dealing with the hijab case, you're dealing with someone saying, okay, I'm wearing something, and you're saying, take that off. Then, the harm is being caused here to the person by saying this is not a practice. Whereas there was no harm being caused to anyone else by saying that that practice was not essential. So, I mean, the thing is, see,
Mm.
in a certain sense, that seems like the fair way to assess it. But unfortunately, we do have a body of long, these Supreme Court cases. So, in a sense, maybe the Karnataka High Court got it right. Okay, you can't really necessarily disagree with them because there's a
Yeah.
lot of Supreme Court precedent over the years, which in itself, there's a whole story behind there of how the Supreme Court actually completely messed this whole thing up. Because when you look at the Constituent Assembly debates over this whole
Mm.
concept of essential religious practice, it wasn't about saying, oh, in this religion, is this an essential religious practice? It was saying that a
Yeah.
particular practice, is it essentially religious or not? It's almost like it's a very minor
Mm.
semantic difference, but it's a huge difference in terms of how it gets applied over the years. And the Supreme Court kind of perverted the whole test over the years with changing it to essential religious practice. Um, but
Mm.
so assuming where we are, there's not a lot you can do about that, perhaps. So maybe we can say that the Karnataka High Court decision not problematic on that part. But on the other one, on the aspect of whether uniforms reasonable restrictions, I mean, it is bizarre, like the kind of observations you see there.
So why did the court held that these were not that wearing a hijab is not an essential religious practice? What were the arguments made by the court, and what was the end conclusion as such?
So the court's reasoning on the essential religious practice issue, as I said, I mean, it follows the Supreme Court
Mm.
tests, which are an issue, and to an extent, there's an argument to be made that there is a
Mm.
particular nature of harm being caused here. But as such, I mean, there's not a lot that you may necessarily be able to legally fault with what it does there, right? Because what they do is they follow the test which the Shabrimala
Mm.
verdict gave them. They've then looked at this translation of the Quran, which has been used by the courts in the past and approved by them. And in that, there
Mm.
is no specific injunction to wear a hijab. And in fact, there are sutras specifically which are pointing out things saying, what, there can be no compulsion on a person in the religion. And I mean, it's a bit weird because I mean, this is
Mm.
going to mean that a lot of things could potentially be argued to not be essential religious practices in Islam.
Yeah.
So I mean, that is maybe a line of attack against that as well. But basically, they said that they can't, that all the
Mm.
sutras which deal with covering up modestly, etc., 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 for women, none of these things are
Mm.
direct orders to a woman that she has to wear something like a hijab, and that there's nothing said.
Mm.
It doesn't say anything that, oh, if a woman doesn't wear a hijab, she will, she cannot be considered a Muslim, or that she will go to hell, or that she will, there's none of that kind of thing in there either, is at least
Mm.
what they found after going through a bunch
Okay.
of different provisions. So that's the reason why they said it's not an essential religious practice. Which I
Mm.
mean, another key thing actually which they raised was that they said that the petitioners didn't do a good enough job of making this clear, of saying that this is an essential. They didn't show enough to the court that there are grounds to say that this is an essential religious practice. So they said, but you know what, let's
Mm.
park that part for a moment, because that can maybe be fine, even if the court finds, right, that this is not an essential religious practice. If you say that, look, we have a right to freedom of expression, we have a right to privacy, that gives us a choice of what we wear, of gives us a choice of what we consider to be our identity, that itself is enough, right? Then you do
Mm.
not need the essential religious practice test to go in your favor, and you can still win the case. And this is where it starts to
Yeah.
get just, I mean, it's just so strange. There's the line, I'm going to read this out. They said this: no reasonable mind can imagine a school without a uniform. So this is about the part, right, where they're saying, is a uniform a reasonable, in a school, a
Mm.
reasonable restriction? They're saying no reasonable mind can imagine a school without a uniform. I mean, what? Then they to establish this, by the way, they're saying this is not a nascent concept. We go all the way back to Gurukul, and there's concepts of people having to wear particular kinds of clothes. And I'm just like, why is any of this here in this discussion? Like, it does not need to be here at all. Then there's a whole thing where one of the arguments which had been tried to be raised was that, oh, this is basically giving police powers to schools, to the government when they're prescribing
Mm.
uniforms, and they reject that. And you know what, fine, let's
Mm.
assume that that is the case. But the most bizarre thing which comes up is that they say, they come to the point that all your fundamental rights, right, can be subject to reasonable restrictions. But what is a reasonable restriction? There are a bunch of tests which have been laid down by the courts over the years, right? So if you have, you're going to look at proportionality. You're going to look at whether or not these things seem arbitrary. Do these are these restrictions discriminatory? They're standard kind of things which you would do. In particular, the proportionality test, right? You'll say, is there a legitimate aim here? Is this restriction actually achieving, that aim? Is it the least intrusive method of achieving that aim? These are all the things which which are supposed to be asked about what is ostensibly a reasonable restriction. Instead, the court just bypasses all of that. And it does this in this insane sleight of hand thing where they say, I'm going to read this out again. However, the petitions we are treating do not involve the right to freedom of speech and expression or right to privacy to such an extent as to warrant the employment of these tests for evaluation of argued restrictions. I mean, how do you arrive at this? According to them, the rights which are being asked for here are rights within a school framework, and a school is a qualified public place. And in these kind of qualified places, your rights become derivative, and they're not like, at their full level. And the other kinds of, by the way, what are the other things which are supposed to be these qualified places are where you're a prisoner, where you're in the army. Supposedly, these are proper analogies for schools, no? I mean, it's bizarre because there's no legal authority cited for this. They're not citing any Supreme Court judgment that says that, yes, schools can be considered qualified public places where your rights now have to be looked at different. I mean, it's madness. There's a point where and I'm sorry to use this language, but I'm sorry. They have a whole discussion of how, you know what, like people who are under trials, even they have to wear, like what the uniform prescribed in a jail is. And then the convicts also have to do that. How is this a valid comparison to like school students, right? And and remember, what you're doing is you're using this to sidestep the question of, okay, is this a reasonable restriction or not? I mean, there are some other apps that then there's even more bizarre comments there. They have a thing about how they say that, if you don't have school uniforms in a school, and if you just allow kids to wear whatever they want, this will lead to chaos on the campus, and then in society, eventually degenerate into society at large. Which again, I mean, what is this? Where is this obsession with uniforms coming from? Number one, and in what way is this going to affect society at large? And I mean, then they even have I mean, this cognitive dissonance which just comes in where they say, the idea of having regulations for uniforms is to create a safe space for students. And which is directly opposite to what is happening to Muslim girl students now, right? Like they're being heckled, they're being forced to take off something which they consider part of their identity, which whether it's because of family pressure or their own choice, by making them take it off, you're not putting them in a safe space at all. But this is the language used in this court order. It's just, it is. I don't even know how to describe it, right? I mean, as I said, maybe you can say the arguments of essential religious practice, they sort of fit within the old Supreme Court's frameworks. But the arguments and restrictions and whether these restrictions are reasonable, I mean, I don't even know how this has been written in a judgment. It doesn't make sense.
Now, one of the questions which the High Court also tried to answer, and which you touched upon earlier as well, is whether the Karnataka order of 5th February, which basically restricted students from wearing hijab, was issued without application of mind and is manifestly arbitrary. And they concluded this in the negative, stating that it does not. So can you take us through the reasoning behind why they think the Karnataka government order basically is sound judgment, was a sound order?
So I mean, there are two parts to that issue. The legal issue, one was, okay, did the Karnataka government have the power to do it? To use this, they use a particular provision of the Karnataka Education Act. Did they have the power to do that? Was this within the scope? And to that extent, again, I mean, not a lot you can argue with. Like, the reasoning seems fine. They say, look, the Karnataka government has the power to issue these kind of instructions under the Karnataka Education Act, so therefore no harm with them issuing this order. But they don't get into the merits of what is raised. And okay, fine, let's, since they're saying that uniforms can be a reasonable restriction, right? However flawed, whatever. So that part where they're saying, okay, where a uniform is imposed, it has to be followed. I mean, going by what the court has already held, however problematically, that's
Hmm.
fine. Okay. What is bizarre though is that the sort of last point in that government order was that, okay, where there are no uniforms, then people have to wear clothes which do not disturb equality, integrity, unity, and public order.
Yeah.
Now, this part is so badly worded, especially the reference to public order, right? Because
Hmm.
in law, public order is a very specific concept.
Yeah.
We've got decades of court judgments, Supreme Court judgments saying that public order is a specific thing. It's not even, you can't even just say a law and order situation is a public order situation. It has to
Hmm.
be much more serious, must involve a real threat of violence, must have a real kind of connection, a risk to society at large before you can call something a public order issue. So,
Hmm.
I mean, the fact that this order is making these kind of comments about clothes disturbing public order is ridiculous, right? Because essentially, you're the only thing you're really actually allowing there is allowing the heckler's veto, because you're not
Hmm.
because it's not as though me wearing a hijab is going to cause a riot. It's someone seeing me wearing the hijab and then be like, "How dare you wear it?" and then like making a ruckus, right?
Yeah.
So that is not something which a government order should in any case ever be doing.
Hmm.
Um, but to get around this again, it's this this sleight of hand, this sidestep which the court does, where they're just like, oh yeah, I mean, it says public order, but like, you don't have to interpret this in the way we look at public order in statutes or in like, the constitutional framework.
Hmm.
It's just like, I mean, look at it, it's a government order, right? They're not really meaning it that seriously. They don't mean
Yeah.
it in terms of public order the way lawyers will talk about it. So don't worry about it. It's perfectly okay.
Hmm.
I mean, I don't even know. I mean, what do you say, right, to something like
Yeah.
that? This is after the Advocate General had also kind of discussed that, oh, there's a this order was a little bit over enthusiastic. But I
Hmm.
mean, just look at this. This is, they say, there is a sea of difference in the textual structuring of legislation and in promulgating a statutory order as the one at hand. No, there's
Hmm.
not. Like a statutory
Hmm.
order from a government, it's a secondary legislation. It's what's called secondary legislation under the act. This cannot just employ random language. So where on earth are they pulling this out from?
Yeah.
I mean, how are you making this argument work?
Hmm.
um it's just bizarre. I mean, so this, I mean, yeah, the rest of the stuff where they say the order is fine, the government is competent to pass it. I mean,
Hmm.
cool, okay, fine, right? I mean,
Yeah.
that will get taken up as a legal issue on appeal. But this other part of it, just, I mean, it's raising so many questions about
Hmm.
what this, what on earth is going on in this judgment.
Yeah.
And yeah, I mean, it's yet another example of why this judgment is, I think, definitely going to be challenged, and why it might see some changes at the Supreme Court.
Okay. Now, Prakasha, with this judgment, the court has like essentially legally validated the ban of hijab in Karnataka. What would
Mhm.
be the impact of this verdict on the fundamental rights which are enshrined in the constitution? Do you see an impact, something on the right to life, even?
I mean, I think what you're looking at is going to be what is, I think, the most dangerous here is that ruling on essential religious practice. Because
Hmm.
now suddenly, if people are going to start saying, oh, why is this woman wearing a hijab at the bank? Why
Yeah.
is a teacher wearing a hijab? Uh, why is this public official wearing it? It's suddenly going to be like, you know what, you don't have a right to wear it, which
Yeah.
really shouldn't be the case. And the point is, maybe that's not what the court is intending, right? And it could be that
Hmm.
eventually a court's going to say, no, 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 that's not what the court, that's not how you can apply this. But that's not going to
Hmm.
stop people from using it. We
Yeah.
saw the Karnataka High Court's interim order, where it had said that, people, that students going to schools now, and that too, it wasn't even schools, it was only meant to be for basically government aided pre-university colleges, which is class 11
Hmm.
and 12. It was only supposed to be for them, that interim
Hmm.
order saying that kids going to those schools will have to not wear any religious attire, and that's if that's prescribed by the college development committee.
Yeah.
That order did not apply to anyone else studying in any institution which was not governed by a college education committee. But what
Hmm.
did we see happen across Karnataka?
Yeah.
Every single institution, schools, degree
Hmm.
colleges, everyone was
Yeah.
applying that order and saying, but Karnataka High Court said. And the
Yeah.
worst part was, The Karnataka High Court was asked to clarify, and they actually expanded it and said, yeah, even degree colleges,
So there is a possibility that someone wearing a hijab could be even stopped at a hospital, stopped from boarding a bus also,
yeah,
just because they are wearing a hijab.
yeah.
That's
I mean, the
that's an actual
problem is
possibility
that
now.
these kind of, when a court pronouncement is done like this without really thinking through what they're doing, or without
Hmm.
putting qualifications, like they could say, now the way they qualify, right, on the reasonable restrictions thing, saying, oh, this is only about schools. If you said that, in terms of this aspect, we're saying this, this does not apply to the context outside the classroom for a girl. It does,
Hmm.
make sure if you're going to say this, you need to add those clarifications, those qualifications, which the court does not do. And so I think we are going to see given, I'm just saying, just looking at the misuse of the interim order, which we had from the Karnataka High Court, I
Hmm.
think there's going to be a huge amount of misuse from this, where it's going to affect Muslim women in public life. The second
Hmm.
aspect of it about schools, your rights, your rights aren't as strong when you're in schools. That's again a very dangerous precedent. While that's limited to schools as of now, but I mean, what next is going to be designated a qualified public space where we're going to suddenly apply the same rules which we apply in prisons? I mean,
Hmm.
the mind boggles, right, that this is going to be the case. And this
Yeah.
judgment opens the door, even if the court didn't intend for it, which, I mean, I'm sorry, a court has to be aware of what it's going to do. But even if the court didn't want this to happen, they've opened the door
Hmm.
for like levels of harassment and misuse, which is going to be used to target minorities, which is going to be used to target, even people, just, think how many girls who are considered to be wearing, unorthodox clothing, they could find themselves targeted by these kind of things, right? You're going to see these,
Hmm.
or people who wear things, as I said, the question that the school argument starts applying to other qualified public spaces. What are we going to see? Are we going to see local villages saying, oh, in the public square you have to wear XYZ kind of clothing, and then it's going to be like, yeah, but that's qualified public space? I mean,
Hmm.
the potential for misuse here is
Yeah.
so staggeringly broad that I
Yeah.
think, there's a real worry. And one of the last few observations in the order also raises another key issue. Like the court almost is accepting that
Hmm.
the protests about not being able to wear hijabs were
Hmm.
being promoted by, and I quote, and they use this term here in single quotes, unseen hands. Now, this is even more dangerous. What this basically, that though this last paragraph there is again going to be used. It's not even a question. It's going to end up being used to say that all
Hmm.
these protests were motivated. These girls weren't actually trying to do anything. There'll be now harassment of these girls. Who was funding you? Who was forcing you? This is going to continue not just, at the schools at an official level. These kind of comments, they will percolate down into society as well, right? They're going to face
Hmm.
heckling and bullying in school about this as well. So, I mean, it's it's really disturbing that the court would include
Yeah.
even this aspect where they say that, oh, we think there's an issue and we don't want to prejudice that investigation, so we're not going to say anything further, but we need to protect social, so we must prevent social unrest and disharmony, and we must protect society, and
Hmm.
there are definitely culprits here behind this. But who really were the
Hmm.
culprits, right? Remember, who were the people who raised actual ruckuses and public disturbances? It was the kids wearing bhagwa
Yeah.
scarves, right? Wearing saffron scarves.
Hmm.
Is that investigation going to be looking into them? As far as we know at this point, no, it's not, right? It's only looking into, oh, it
Hmm.
was Campus Front of India, oh, it was these guys who were funding the girls. There are investigations being launched against these poor girls, who are just
Yeah.
students. And yeah, so and this is
Hmm.
again stuff which the court has allowed itself to be part of this, and
Hmm.
it's really sad. It's allowed itself to be part of things which are going to affect people's fundamental rights in Karnataka, and I think beyond. Like, you're going to see orders passed by state governments on the same lines as what this High Court has said. And say, yeah, see, Karnataka High Court said it.
Hmm.
So, you know what? We've got sanctioned to do it. Okay, you want to fight about it? Go to the High Court and fight, right? And you'll just have this
Hmm.
constant, like, sort of scope for conflict and confrontation on a communal issue,
Yeah.
which we know who that benefits, and it doesn't benefit society at large. It only benefits people of a particular social and political persuasion. So
Hmm.
it's
Like,
unfortunate now
yeah.
that this court order is going to play a role in that.
Okay, so my last question was, Vakasha, was what is the way ahead now? Will this case be taken to the Supreme Court as well? Like, does it hold any water over there?
I mean, so there had been some attempts to kind of take this case up to the Supreme Court. At that time, the CJI had said, this is coming
Hmm.
from one state. It's not yet a bigger issue. Let it be resolved within that state's High Court, and then we'll see.
Hmm.
Now that the High Court has
Yeah.
passed its order, that order can be appealed, and other petitions can maybe be tagged with it as well, because we have seen also that there have been some incidents in other states as well, right, where this stuff is being
Hmm.
done. So yeah, I mean, it's very much now the time for the Supreme Court to look at this. I mean, the hope is that they're going to say, look, there's grounds to stay this order. It's perverse. It does, it doesn't have a lot of sense or whatever. The effect that this order could have is so severe on people's rights that we've got to stay till we make a final determination. That's a possibility.
Hmm.
Yeah, I mean, look, I'm not necessarily going to say that the Supreme Court will say, oh, hijabs have to be allowed everywhere, and oh, hijabs are an essential religious practice. But I do think, at least I'm hoping we'll get a more considered, examination of the issues
Hmm.
of whether it's essential religious practice, or more pertinently, I think the question of when it's a reasonable restriction or not. And I'm really hoping at least that we get a complete smackdown of this idea of this qualified public space and equating schools to
Hmm.
war rooms and prisons, which is,
Yeah.
I can't imagine when they were writing this and they thought this makes perfect sense. Schools and prisons, same thing. I mean,
Hmm.
how on earth does that make sense? Yeah, I mean, you're just flipping what are you treating a school as? Like, what have
Hmm.
you made a school into? And this is, remember, just after they've been talking
Yeah.
about schools as safe spaces, and
Yeah.
suddenly we'll now then say, oh, but we can compare them to a prison.
Yeah.
What? I mean, just it's and at least hopefully the Supreme Court will. So the best case scenario, Supreme Court stays
Hmm.
it, hears it,
Yeah.
ends this stuff, right? Worst case scenario is that Supreme Court will take some time, will not stay it. In the meanwhile, it's going to be misused. But
Yeah.
let's see. One can only hope, I guess, that we know that there are appeals being filed. We know there are other
Hmm.
petitions which are going to be tagged with it. So hopefully something will
Yeah.
get
Let's hope
resolved
so.
there.
And like, it's been a few years since both of us have been in school, but it's of course months of like March, April, May are like the exam months also. So I can't just like even imagine what the
Yeah,
students are going through. But
yeah.
yeah,
I mean, the disruption is terrible because kids
yeah,
have
of
not
course.
been allowed to sit, right? Even during this
Hmm.
time, girls who were going
Hmm.
weren't being allowed to sit. I mean, this is chaos. And
Yeah.
remember, this is not just this year. It's now going to
Hmm.
continue next year as well. And I mean, what are the implications it's going to have on
Hmm.
kids' right to education?
It's
It's
bizarre. Yeah.
bizarre,
Well, thank you,
bizarre.
Vakasha, for joining us and help us break down the verdict as well. It's always a pleasure speaking to you.
Always a pleasure, Hemant. Speak soon.
If you liked listening to this episode, please subscribe to The Big Story for episodic updates. We're available on Apple, Google Podcasts, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website, and for any feedback, please shoot an email to podcast@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.